very, very wise individual.
Your Honor, you can go ahead and begin.
We can go ahead. Okay, great. All right. Good morning again, ladies and gentlemen. We are all here. We are going to start the case of Marks versus Sonny's Rooftop Bar. My name is Judge Jeffrey Harkavy, and it's my honor to be presiding today. Scoring attorneys, if you will please look to the two buttons on the lower left of your screen and turn off your audio and video. Looks like everyone's already done that. And these should remain off until the trial ends. You should also have your video set to hide all non-video participants. That means only the people on the screen right now should be advocates and me, although I'm going to ask every person who is competing in this round, counsel, second chairs, and witnesses, you can go all please go ahead and turn on your screens for introductions, and then we will proceed further. So we'll start with introductions, starting with plaintiff's side, with like plaintiff's trial counsel, second chair, and witness to please introduce themselves at this time.
Yes, Your Honor. Good afternoon, Your Honor. My name is Christina Davoudpour, and I'm joined today by my second chair, Laura Baikal.
Good afternoon, Your Honor.
Good afternoon.
And by my witness, Morgan Levin.
Good afternoon, Your Honor.
And today we will be representing the plaintiff, Miss Ethel Marks, on behalf of her deceased daughter, Jessica Marks.
Thank you. Defense introductions, starting with defense trial counsel, please.
Yes, Your Honor. Good morning. My name is Hanan Yousuf, and I represent the defendant, Sonny's Rooftop Bar today. And our representative is Sonny Mehta, who's present here today. My second chair is Mr. Avery Rose, and he will be handling all the technology for today's round.
Good morning.
Very good. Thank you. Good morning. Okay, so before we begin opening statements, are there any preliminary matters on behalf of the plaintiff?
Yes, Your Honor. The plaintiff would like to constructively swear in all witnesses pursuant to Rule 603.
Any objection by the defense?
None from the defense, Your Honor.
Okay, all witnesses are constructively sworn in, so they do not have to be sworn in prior to the start of their testimony.
The plaintiff also invokes Rule 615 to constructively sequester all witnesses with the exception of party representatives.
Any objection by the defense?
No, Your Honor, but we'd just like to remind the court that our party representative is Miss Sonny Mehta.
Understood, and party representatives are permitted to remain in the courtroom throughout the trial and are not constructively excluded. Otherwise, the motion is granted.
Yes, Your Honor. There are also a couple pretrial orders we'd like to bring to your attention.
Go ahead.
Pursuant to pretrial order 2, Judge Pasquarello has granted a motion to bifurcate this case, and today's trial will deal only with liability, not damages.
Understood. The court has read the pretrial order, and this is a bifurcated trial. We will only be trying the issue of liability today, and reserve any trial on the issue of damages depending on the outcome of the first part of the bifurcated trial.
Yes, Your Honor. And we would also like to mention that Judge Pasquarello has pre-admitted 3 exhibits. Pursuant to pretrial order 11, exhibits 1, 22, and 23 are pre-admitted and may be used at any time. Those are a plea agreement between the defendant and the Los Angeles County DA from 2018, an autopsy report, and a police report.
The court is aware of this order. Thank you for reminding the court, and the court takes judicial notice of the previously ordered pretrial orders.
There are also 2 stipulations we'd like to bring to the court's attention. Those are stipulation 14. Jessica Marks was born January 20th, 2000, and stipulation 15. On March 24th, 2019, Sonny's Rooftop Bar was licensed to sell alcohol under Section 23300 of the California Business and Professions Code.
The court is taking judicial notice and is accepting into evidence all stipulations, including 14 and 15, and all such stipulations will be presented to the jury for their consideration and during deliberations.
Yes, Your Honor. And with that, the plaintiff has no more pretrial matters.
Thank you. Any pretrial matters on behalf of the defense?
Yes, Your Honor. May we assume that all exhibits 1 through 27 are pre-marked as such for identification purposes throughout this trial?
Yes.
And given the virtual nature of this trial, how would you like any connectivity issues to be handled in your courtroom?
Excellent question. If it's just a momentary glitch, we'll just wait to clear it up. If it's going to be longer than that, we will stop time and allow the person who's having difficulty to do whatever they're able to do to resolve them, including, if necessary, having to log off and log back on again.
Yes, Your Honor. And we'd just like to ask your preferences for displaying exhibits for witness identification. Would you prefer that we display the exhibits before entering them into evidence during the witness identification period, or constructively, of course, outside the jury's view? Or would you like us to display those exhibits after they've been admitted into evidence?
Option number one, go ahead and display them. This will be deemed constructively outside of the presence of the jury, but that way the court is able to view the specific exhibit you're talking about and better able to respond to any concerns or objections to that exhibit.
Yes, Your Honor. And another question about those exhibits. Would you like us to formally ask permission before displaying those exhibits, or just simply state what we're doing for the record?
You can go ahead and put them up when you're ready. Again, at that point, it'll be presumed that the jury is not seeing this exhibit until such time as appropriate foundation has been laid. And if there are any objections to the exhibit, the court has made a ruling on the objections.
Yes, Your Honor. And finally, pursuant to the online tournament rules under number 9, D3 specifically states that we just wanted to confirm with the court that the time limits for direct examinations have been extended to 9 minutes instead of 8.
Is that the plaintiff's understanding as well?
Yes, Your Honor.
We will be following that rule.
And finally, for timekeeping, we would just like to confirm with opposing counsel that timestamps will be posted in the chat for everyone to see.
Yes, Your Honor.
Very well. Thank you.
And with that, Your Honor, the defense is ready to proceed.
Thank you. Thank you to both counsel. We will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Okay, so I'm now in speaker view as well. And plaintiff, you may give your opening statement at this time, please.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. It's just common sense. Today, you're going to hear about a girl named Jessica Marks who went to Los Angeles to visit her best friend on spring break. She was a kind, fun-loving 19-year-old college student. And on the night of March 24th, 2019, she went to a bar with her best friend. That bar is called Sunny's Rooftop Bar. And Sunny Mehta is the defendant in today's case. Jessica and her friend were just hanging out at the bar and decided to order some drinks. Now, you might be wondering why we're suing the bar when she's the one who ordered her drinks. But that's because you'll hear today that even though Jessica was obviously intoxicated, Sunny Mehta kept serving her. Jessica Marks was slurring her words. She wasn't making sense, and she was stumbling around. Yet, Sunny Mehta never cut her off. Afterwards, she got into her car and she tried to drive off. But that's when she, unfortunately, drove into a ravine. The plaintiff has sued Sunny's Rooftop Bar for wrongful death. In the state of California, there's a law called the Dram Shop Act, which holds bars responsible for injuries caused by overserving. But the plaintiff holds the burden of proof. This means that we have to prove 4 things by a preponderance of the evidence. Or in other words, it's more likely true than not true. 1, that Jessica Marks was a minor. 2, that Sunny's Rooftop Bar served Jessica alcohol. 3, that Mr. Mehta knew Jessica Marks was obviously intoxicated when they served her the alcohol. And 4, that her intoxication is what led to her death. We have to prove that the defendant should have known and did know that Jessica Marks was obviously intoxicated, and that her intoxication is what led to her death. Members of the jury, if you're even 51% convinced, if the scale tips even a little bit more in our favor, you have to rule for the plaintiff. It's just common sense. Today, you're going to hear from Morgan Levin. She's going to give you the timeline of their night out at Sunny's Rooftop Bar. She'll tell you about the amount of drinks they ordered that night, how many times they interacted with Sunny Mehta, and even the way that Jessica Marks fell and stumbled onto Mr. Mehta that night. In fact, Ms. Levin will show the jury a video, one that was taken at Sunny's Rooftop Bar. And in that video, you'll see how Jessica was acting clearly intoxicated. I want you to pay close attention to her behavior by the end of this trial. And think to yourselves whether or not that was acting obviously intoxicated. You will see the timeline of when that video was filmed, when Mr. Mehta went and bust down their tables, and how it's just common sense that Mr. Mehta has to have seen her acting the way she does in the video. Members of the jury, it's just common sense. As the trial goes on, I want you to ask yourself, what truly makes sense? Because members of the jury, it's just common sense. At the end of this trial, I will come before you and ask you to find the defendant liable. Thank you.
Thank you, counsel. Opening statement by the defense, please.
Yes, Your Honor, may I proceed?
Please.
May it please the court, Your Honor, opposing counsel, and members of the jury. The life of Jessica Marks was in her own hands. You just heard Ms. Davoudpour come before you and talk about the tragedy that happened on March 24th. And we as the defense agree how terrible, how short Jessica's life was when she had so much ahead of her. But the truth is, Jessica made her own decisions that night. From her ID, to her drinks, to her car keys, to her steering wheel. It's just common sense, members of the jury. This was all in her hands. My name is Yousuf, and today I represent Sunny's Bar today in today's case of Ethel Marks versus Sunny's Rooftop Bar. Now, as the defense today, we hold absolutely no burden to prove anything. Our responsibility lies with the plaintiff and the plaintiff alone to fulfill. They must prove their case by a preponderance of the evidence. That means that the evidence in today's trial must go in their favor by over 50%. And we're confident that they won't be able to meet this burden. They will be able to show you that Sunny's Rooftop Bar knew that Jessica was obviously intoxicated when they served her, and they will be able to show you that Sunny's Rooftop Bar caused Jessica Marks' death. Because you're going to hear today how Jessica chose to get drinks from places the bar had no idea about. These were her drinks in her hands. No point in oversuing her. If by the end of today's trial, you see that the plaintiff has met their burden, then at that point, the defense will bring forth what's called an affirmative defense. All this means is that we're going to ask you to evaluate the choices of Jessica Marks. At this point, we'll have the burden to prove by a preponderance of the evidence that it was Jessica Marks' actions that led to her death, instead of Sunny's rooftop bar. And we only have to show this by about 50%. Members of the jury, you're going to hear today how Jessica got a fake ID to drink alcohol. It was Jessica who drove to Sunny's bar with the intent to drink. It was Jessica who chose to get drinks from other places the bar didn't know about. Jessica chose to have her keys in her hand that night. Jessica chose to put those keys into the ignition of her car. She chose to drive home that night. She chose to put herself in danger as well as the other people on that road that night. The choices Jessica Marks made on the night of March 24th were all in her own hands. You're gonna hear how it was her ID, her drinks, her car keys, her steering wheel, her choices, her life. You're gonna hear how it was all in her own hands. After you hear the testimony of all the witnesses here today, the defense is confident that you'll have to find Sunny's rooftop bar not liable for the death of Jessica Marks, because her choices that night were in her own hands. Thank you.
Thank you, counsel. Before the plaintiff calls its first witness, I will ask everyone to now switch to gallery view. Again, that's in the upper right-hand portion of your screen. This will allow you to see the attorneys and witnesses at the same time. Plaintiff, you may call your first witness.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand. Could you please introduce yourself to the jury?
Hello, my name is Morgan Levin.
And could you tell us a little bit about yourself?
Sure, I'm a junior at UCLA. I'm a biology major.
And do you know why you're here today?
Yes, my best friend, she died, and I watched it happen.
Now, I know this may be difficult for you, so if at any moment you just need a second, please let me know. How did you know Jessica?
Well, Jessica and I, we've been friends since middle school. You know, we grew up together. We did everything together. We went to high school. We were both in the same class, and then we went to separate colleges.
And what was Jessica like?
She was so full of energy. She was bright. She was outgoing. She'd walk into a room and it would just light up. I really admired that energy from her.
Now, I want to talk about March 24th, 2019, when Jessica came to visit you for her spring break. Did you and Jessica hang out that day?
Yeah, the night of March 24th, we went to her Airbnb that night and we hung out.
What'd you guys do?
We just sat on the couch, talked. I think we both had maybe a glass of wine, took some pictures. It was fun. And then we left at around maybe 8:30 to go to Sunny's rooftop bar.
Now, I want to go through the events of that night. What time did you guys get to Sunny's rooftop bar?
We got there at around 9 p.m.
And around what time did you guys leave?
Maybe around 11:45 p.m.
And what employees were working there that night?
I remember Sunny Mehta, the bar owner, was serving drinks that night. And we also saw Frankfurt, who was behind the counter making the drinks.
And what did you guys do when you got there?
We sat down, we walked past the bartenders, and we started ordering drinks.
Who ordered the drinks while you guys were at Sunny's?
Jessica did.
Your Honor, I'd now like to display Exhibit 17, constructively out of the presence of the jury.
Yes.
Ms. Levin, what are we looking at?
This is the receipt from the night of March 24th.
Is it a
these are
fair, is it a fair and accurate depiction of that receipt?
Yes, it looks like it.
Your Honor, I now move to offer Exhibit 17 into evidence.
Any objection?
Objection to hearsay, Your Honor.
Counsel.
Your Honor, these are, first of all, these are statements entered in by computer, so they're automated statements. And second of all, they're party opponent statements under 801D2A.
Response, Your Honor.
Yes.
Your Honor, nothing on this receipt was made by a computer except for the automated messages such as Sunny's Rooftop Bar and the date and the time. All the orders were put there by a human, and that would make it a declarant for the statement. Also, Morgan Levin's signature is on this, therefore they must have adopted this statement, meaning there was also a declarant involved. Also, Your Honor, the exception that opposing counsel mentioned, 801D2, would not apply in this case because the two parties today are Jessica Marks and Sunny's Rooftop Bar, and I don't see either name on this receipt, and no foundation for that has been laid.
I see Sunny's Rooftop Bar at the top of the receipt. Am I misreading that?
Yes, Your Honor, but opposing counsel has not laid the foundation that Sunny's Rooftop Bar had any knowledge or laid any foundation for this to be a statement made by party opponent.
I'm going to overrule the objection. I believe it is admissible as a statement by a party opponent. I do agree that even though this is presented in computer form, a human being entered in the specific items on the receipt. I agree that in all probability, the name at the top, the address, and the date and time stamp are computer generated. However, the table number and the items were entered in by a person. I believe sufficient foundation has been laid to show that this was the receipt issued by the defendant, and therefore it's admissible as a statement by party opponent. So the objection's overruled and Exhibit 17 is received into evidence.
Yes, Your Honor.
And may be shown to.
Yes, Your Honor. Ms. Levin, what drinks did you guys order that night?
So we ordered a bottle of wine. We ordered 3 White Claw cans, an IPA draft beer, and then also an IPA can, so another beer, and then 2 green tea shots.
And how is
I think there were also.
Go ahead. Go ahead.
There were also some drinks that weren't on the receipt as well.
How was Jessica acting throughout the night?
She got worse as the night continued. She started getting sleepy. Her eyes got bloodshot. She started smelling like alcohol. I was worried for her.
And did any incidents occur while you were at the bar where Jessica seemed intoxicated in front of Mr. Mehta?
Yes, she stumbled into Sunny Mehta at around 10 p.m.
And did Sunny Mehta say anything about that?
Yeah, well, Jessica just fell right into him, and Sunny said, I think we might need to cut this one off.
And did Sunny ever say anything else in relation to Jessica throughout that night?
Yes. As we walked out that night, he asked me, I hope this one's not driving. And he pointed to Jessica.
And how many times would you say that Jessica and you interacted with Mr. Mehta that night?
Gosh, I think it was around 8 to 10 times.
Do you have any videos or pictures of how Jessica was acting that night?
Yes, I took pictures all throughout the night, and I think I also took a video.
Your Honor, we are now displaying Exhibit 10, 15, and 60 constructively out of the presence of the jury.
Yes.
Ms. Levin, what are we looking at?
I see 2 pictures there, and then also a video that I took. I took both the photos and the video.
Are these fair and accurate representations of the photos and videos you took?
Yes, they look like it.
Your Honor, we now move to offer these 3 exhibits into evidence.
I would need to see the video first to see if there are any possible objections as to the video. All right, do you intend to play the video?
Yeah, we intend to play the video after the next question.
Okay, well, as to the two photographs, any objection to those being admitted? Defense is on mute.
Yes, sorry, Your Honor. Yes, Your Honor, as to hearsay.
As to the two photographs?
Yes, Your Honor, may I be heard?
Yes.
These pictures assert a truth value as to how many drinks Jessica had that night, and therefore they would be considered hearsay since they're also out of court as well.
Okay, so hearsay, as you know, is an out-of-court statement. How are the photographs constitute statements?
They were taken by a declarant, which would be Morgan Levin, and they show the truth value and of how many drinks Jessica had that night. They are asserting how many drinks Jessica had that night.
Your Honor, may I
Yes.
respond? Hearsay, like we've said under 801, is an out-of-court statement. However, these are not oral assertions or written assertions, therefore they cannot fall under hearsay.
Yeah, a statement has to be come from a person. In this case, we have a photograph which does not contain any statements such as a caption or something that was written or superimposed onto the photographs. So as to the two photographs, and I'll make a separate ruling once I've seen the video, as to the photographs, the objection on the grounds of hearsay is overruled, and the two photographs are received into evidence and may be shown to the jurors.
Yes, Your Honor. Ms. Levin, at what time were these photos and videos taken?
The first photo was taken around 10:57 p.m. I remember I posted the video at 11:11 p.m. and then I took that last photo at 11:32 p.m.
Your Honor, we would now like to show the video.
Please proceed.
Apologies for the technical difficulties, Your Honor. You gotta love online Zoom.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a silly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Your Honor, Ms. Levin, how would you say Jessica's acting in this video?
I remember when I took that video, she was
Objection, Your Honor. They haven't entered this video into evidence.
Yes, Your Honor. Your Honor, we would now like to move to offer Exhibit 10 into evidence.
All right, any objection to Exhibit 10 being received into evidence?
Hearsay, Your Honor, to the statements made by Jessica Marks.
Okay. Response by the plaintiff.
Your Honor, these aren't hearsay under 801 D2A as they are statements made by Jessica Marks herself.
How is that not? But she's not a party opponent.
Oh.
So how is the fact that she made the statements admissible?
Well, the statements are admissible because we aren't using them to show the truth of the matter asserted. We're simply using them to show that to show her conduct that night.
All right, the objection, first of all, as to the video itself, and I'm separating video and audio for a moment. Any objection to the video itself is overruled. Foundation has been laid, and the video itself does not contain statements. So the video itself is admitted. As to the statements made, the court will sustain the objection in part, and this will have to be edited later, only to those statements that would potentially be offered for the truth, such as the cost of the drinks. But as to the other statements, such as her thanking the members of the Academy, the last statement that she made are neither true nor false. And those statements that will be admitted over hearsay objection because they're being offered for a non-hearsay purpose. Again, it's not hearsay because it can either be true or false. It's just simply a statement being made. But that will be done at a later point in time before it's ultimately shown to the jurors.
Yes, Your
So
Honor.
you may ask, but you may ask a follow-up question, the follow-up question that you were about to ask.
Yes, Your Honor. Ms. Levin, how would you say Jessica is acting in this video?
She wasn't herself. She was slurring her words. She was dropping beer cans.
Objection, facts not entered into evidence. The statements made by Jessica Marks in this video, the ones that asserted truth value, were not entered into evidence. So this witness testifying to the slurring of her words and how she talked would be assuming facts not entered into evidence.
Your Honor, may I respond?
Yes.
Like you previously just said, you said you would admit the statements where she was talking about the Academy. The only statements that would not be admitted were the ones that were going to the truth value, which was the ones about how much the price of the beer cans cost. However, my witness is simply referring to the fact where she was talking about the Academy and how she was slurring her words in those statements. And furthermore, she's talking about the dropping of the beer can, which was admitted into evidence for the video graphic proof.
Okay. The objection will be overruled. The witness can testify not only to her personal observations, because she was there, she's recipient to what is shown in the video, as well as interactions both before and after, and portions of the video. Most of the video will end up being received because it doesn't go to the truth. So the witness is able to testify to her perceptions of those observations as to the slurred speech, etc. So the objection's overruled.
Yes, Your
The
Honor.
witness may answer.
I'll re-ask the question. How would you say Jessica's acting in this video?
She, like I said, she was slurring her words. She's dropping her beer cans. She's not even making sense. She had drank so much alcohol, and I was so worried for her.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination, please.
Yes, Your Honor. Ms. Levin, let's just start off with why you're here today. Jessica's family was going to sue you, weren't they?
That's right. Mrs. Marks said right after Jessica Marks crashed, but that never happened.
Right, and now here you are testifying on behalf of that same family, right?
I'm testifying to what I know is right, and yes.
So that's a yes, you're testifying on behalf of Jessica Marks' family?
Yes, Mrs. Marks.
Right. You were also drinking that night on March 24th, weren't you?
I was. I think I had a beer, a glass of wine, and a green tea shot at the very end of the night.
You had trouble remembering things during your deposition, isn't that right?
That's right. It's been 2 years since that happened.
You even changed your story when Officer Gaskins initially asked you how many drinks you had, right?
That's correct. But I remember that I had 3 drinks.
Redirecting you back to my question, that's a yes, you changed your story with Officer Gaskins?
I can't remember exactly what was going on during that conversation, but I do know that I had about 3 drinks.
I can remind you, Officer Gaskin asked you how many drinks you had that night, right?
When was this?
This was when Officer Gaskin was asking you what happened after Jessica Marks died.
I can't remember exactly. I don't remember what was happening.
Your Honor, permission to display Exhibit 23, which has been pre-admitted.
Sure, go ahead.
I want to direct the court's attention right to the end of that paragraph, and I want you to read in your head as I read aloud. I asked Levin how many drinks
Is
Jessica
that,
had.
excuse me, counsel, is that request to read being directed to the court or to the witness?
To the witness, Your Honor.
Okay, thank you.
I asked Levin how many drinks Levin and Jessica had at Sunny's. Levin said Levin and Jessica had not had any drinks as they were not 21. I read that correctly, didn't I?
Yes, I think this is my first time seeing this document.
So you don't remember changing your story with Officer Gaskins?
No, I remember that I spoke with some EMTs and I think a few police officers, but I don't remember what I said to them.
So it's your testimony here in court today that your story has stayed the same throughout the entire incident.
Well, I can tell you that I don't remember ever saying anything to those police officers. I mean, I guess I must have, but.
Okay, so let's talk about what you do remember. I want to talk about March 24th. Before you even stepped foot into Sunny's bar, Jessica was the one to get you a fake ID, wasn't she?
Objection, Your Honor, relevance. May I be heard?
Yes.
Your Honor, it's already been stipulated that Morgan Levin and Jessica Marks were underage, so any reference to the fake IDs is irrelevant in today's case, as we already know they were underage.
Response, Your Honor.
Yes.
While that is true, we're not offering this evidence to show that they're underage. We're offering this goes to Jessica's intent to drink alcoholic drinks, and therefore goes into our affirmative defense that Jessica Marks disregarded her duty to the safety of herself and the safety of the others around her when she had this fake ID.
Any response by the plaintiff?
Your Honor, I still stand by my statement. It is irrelevant because we already know, as it has been, that she is under 21.
I'm going to overrule the objection. I believe
Yes,
it is
sir.
relevant on the issue of it is undisputed that the decedent and the witness on the stand were both under 21 on the day in question, but the court believes the possession and use of any fake ID is relevant to any potential affirmative defense or determination of comparative negligence if that is an issue that the jury decides to take up.
Yes, Your Honor.
May I proceed, Your Honor?
Yes, please.
Now, Jessica also had a fake ID for herself too, didn't she?
Yeah, she did.
Now, before you went to Sunny's bar, Jessica actually had a glass or two of wine, right?
That's right. We both did.
And after she drank that alcohol, Jessica drove to Sunny's bar, didn't she?
That's right.
And once again, this was all before even stepping into Sunny's bar, right?
Yes.
Now, let's talk about where you could have gotten your drinks from. You were actually taking shots from other people that night, weren't you?
I don't remember ever taking a shot from another person. I know Jessica once got something from Frankfurt, but aside from that, I can't really remember.
Is it your testimony here today that you never took shots with anyone at Sunny's rooftop bar March 24th of 2019?
Not to my knowledge, no. I mean, we had the green tea shots.
Your Honor, permission to display Stevie Redger's fact deposition.
Granted.
And we apologize for any technical delay or difficulties.
Understood.
Objection, Your Honor. This hasn't been entered into evidence.
Overruled, subject to any further objection. I believe it's being offered for potential impeachment.
Oh, yes.
So I have to first see what portions they're asking about. I don't believe they're seeking
Yes, Your Honor.
a motion to introduce the deposition yet.
Yes, Your Honor.
Now, Your Honor, we'd like to direct the court's attention to page 6, line 9. And I want you to read in your head as I read aloud, Miss Levin. We took a shot together, not Kendall, me, Jessica, and the person she was with. I read that correctly, didn't I?
Yes, but I've never met Stevie Redger.
According to Stevie Redger's statement, you were taking shots with him, weren't you?
Yes, I think so.
And that shot that you took was fireball, wasn't it?
I don't remember what kind of shot I had. I've never met Stevie Redger.
You didn't remember meeting Stevie Redger, but clearly you had shots with other people that you didn't mention in your testimony. So I want to talk about those shots. That fireball isn't on the receipt that you signed off on, was it?
I don't remember ever having a fireball shot. There was none on the receipt.
And you never told Sunny about any fireball shot, did you?
No, I don't remember taking one.
And the rum and coke Jessica told you she had, that wasn't on the receipt either, was it?
Yes, that's correct.
Now I want to talk about Jessica's choices. I want to talk specifically about the choices she had in her hands that night. It was Jessica who had the fake ID, wasn't it?
Yes, that's right.
It was Jessica who ordered the drinks that night, wasn't it?
Yes.
It was Jessica who had who had those extra drinks like the rum and coke you testified about earlier, right?
Yes. Yes.
Now, to get more specific, I want to break down the choices Jessica made as she was leaving the bar. You actually tried to stop Jessica from driving home, right?
I did. I called an Uber and I told her to get in with me, but she was crazy.
You asked her to get into an Uber, right?
Yes.
But it was Jessica who got into that car, right?
That's right. I tried everything, but she did.
It was Jessica who put her keys into the ignition of that car, wasn't it?
That's correct.
It was Jessica who still had the steering wheel in her hands, right?
That's right.
And it was Jessica who chose to drive home that night, wasn't it?
Yes, she did. She was drunk.
Your Honor, no further questions.
Thank you. Any redirect?
Briefly, Your Honor.
Please.
Miss Levin, who provided you and Jessica with the drinks that night?
It was Sunny Meta and Frankfurt Johnson.
Thank you, Your Honor. No further questions.
Any recross?
No recross necessary, Your Honor.
All right, thank you. The witness is excused. Thank you for your testimony. Any further witnesses or evidence on behalf of the plaintiff?
No, Your Honor. At this moment, the plaintiff rests.
Thank you. Defense, you may call your witness.
Your Honor, at this time, the defense calls Sunny Meta to the stand. May I proceed, Your Honor?
Yes, please.
Introduce yourself to the court.
Good morning. My name's Sunny Mehta.
And what do you do for a living, Miss Mehta?
Well, I'm a businesswoman and I'm currently in between ventures, but my most recent one was Sunny's Rooftop Bar in Malibu.
And what was your job at Sunny's Rooftop Bar?
Well, I was the owner, but I was also a server at the bar.
What was it like spending time with the customers as a server?
Oh, honestly, I loved it. That's why I worked as a server and not just the owner. I love building rapport with my customers. I think that's where I shine, really.
And were you working at Sunny's Rooftop Bar on March 24th of 2019?
Yes, I was. I was serving tables that night.
Could you describe how the bar was that night?
It was a Sunday evening in March, so it wasn't exactly super busy. But even then, it was just me and another bartender on staff that night, so we were a little short.
And on that evening, did you see Jessica Marks and Morgan Levin walk in?
I did. I believe they walked in at around 9 p.m.
And could you describe how they walked in?
Normally, like any sober person would. They sounded pretty sober too, from what I overheard.
And who was serving Morgan and Jessica drinks that night?
Oh, that would be me. I was the only server, so I was tending to all of the customers in the bar.
And if I showed you their receipt, would you be able to recognize it?
Oh, yes, I would. I checked all of the receipts from that night.
Your Honor, we are now displaying what has been previously admitted as Exhibit 17 for the
Yes,
jury. As their server, do you know what drinks Jessica and Morgan had?
Yes, I was the one who brought them those drinks.
Could you tell us what those drinks were?
Well, it's like on the receipt, a bottle of wine, a couple beers, some White Claws, and a green tea shot, or a round of green tea shots.
And now that we've talked about the drinks you served, Jessica, let's talk about the drinks that you didn't just list off right now. Morgan Levin just talked about a fireball in their testimony. Do you see a fireball on this receipt?
If I'm reading it right, then no, I don't. I just see the green tea shots.
Do you remember serving a fireball to Jessica?
No, I don't.
Do you remember serving a rum and coke?
Well, at my bar, we call it a Captain and Coke because we use Captain Morgan rum, but no, I don't remember serving them that.
Now let's talk about what drinks Jessica and Morgan had. Let's talk about their behavior. At any point, did you see Jessica or Morgan looking drunk?
Jessica looked completely sober the entire night, but Morgan, I wouldn't say she was drunk. She looked a little buzzed or sleepy towards the end of the night.
Was Jessica ever slurring her speech in front of you?
No, not that I can recall. Her speech was very clear.
Were her eyes ever bloodshot?
No, to the best of my recollection, her eyes were fine.
Did you ever see her stumble?
No, I can't remember a single instance where I saw Jessica stumble.
Now I want to focus on some of the things we've heard throughout trial today. Were you here when when Morgan said Jessica and Morgan were drinking wine before coming to your bar?
I do seem to remember that, yes.
When you were serving them drinks on March 24th, did you know that they had alcohol before coming to your bar?
No, I didn't. I mean, I watched them walk in. They looked completely sober to me. I just couldn't tell.
And Morgan also said that you told Frankfurt that Jessica should be cut off. Do you remember that interaction ever happening?
No, I don't. If I thought that she should have been cut off, I would have cut her off.
And did you hear when Morgan said that you told Jessica you hoped she wouldn't drive?
I did hear when she said that, but I think she's mistaken. I was actually talking to Jessica about Morgan, because like I said before, she looked a little sleepy towards the end of the night, and I didn't think she should be driving.
And Morgan also showed us Exhibit 10, which was that video of Jessica the night of March 24th. Were you there when that video was taken?
No, I wasn't. I didn't see the video being recorded. From what I can tell, I'm not in the video, so no.
At any point throughout that night, did you see Jessica acting the way she was in that video?
No, I didn't. I never saw her, I don't know, fooling around or looking as goofy as she did.
Now, based on what you've heard today in trial, who ordered the drinks on March 24th?
Well, based from what I've heard and from what I saw as a server, it seems like Jessica was ordering her own drinks that night.
Who was the person who drove to your bar that night?
Based on what I've heard, that would also be Jessica Marks.
And who was the person who decided to drive home that night?
Once again, based on what I've heard, unfortunately, I believe that's Jessica Marks as well.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Mehta. Now, I just have a couple of questions. I want to start by talking about Jessica's ID. Your Honor, I'd now like to display Exhibit 3 constructively out of the presence of the jury.
Please proceed.
Ms. Mehta, what are we looking at?
It looks to be a driver's license.
Or is it a fair and accurate depiction of a driver's license?
Well, if you're talking about Jessica Marks's, then I never actually saw this before my deposition, but it is the same as I was shown in my deposition.
Your Honor, I now move to offer Exhibit 3 into evidence.
Any objection?
Yes, Your Honor. As to relevance, pursuant to issue number 11, the defendant doesn't need to know that Jessica was a minor that night. So entering this exhibit would make no fact in this case more or less probable, since her knowledge in this regard has no bearing on the facts of this case.
Your Honor,
Didn't you, though, elicit testimony about the ID earlier during your cross-examination of plaintiff's witness?
Yes, Your Honor, but what opposing counsel is doing here is showing that Sunny Mehta had knowledge of Jessica Marks being underage, or that she had her ID the night of the incident. My witness just testified that she never saw this the night of the incident, and neither would it matter if she knew if Jessica Marks was a minor at the time.
Your Honor, may I respond?
Yes.
I'm using this to show that Ms. Mehta did in fact see this ID, as she will state, and we're just simply using it to show that she did get this ID, and she was the one who supplied Jessica with the drinks because she saw the fake ID. And because of that, it wasn't fully her choice, as Ms. Yousuf's theme is. In fact, Ms. Mehta is the reason at all that Jessica Marks had a choice to drink, and consequently, it's still Ms. Mehta's fault that Ms. Marks is dead.
If the witness is going to testify that she saw this ID on the night in question?
Yes, Your Honor. She saw the ID before serving them drinks.
Okay, so based upon that offer of proof, I'm going to overrule the objection on relevancy based upon that foundation to be laid. Also, I believe the defense has opened the door to this information, this document being brought in, and that it was specifically discussed and raised by the defense on cross-examination of plaintiff's witness. So the objections on relevancy are overruled, and the you can lay the foundation for that the witness saw this exhibit on the night in question.
Yes, Your Honor. Ms. Mehta, you saw this ID before serving Jessica her drinks, right?
Well, I mean, I must have. I card anyone that looks under 45, and I think we'd all agree that Jessica Marks looks under 45. I don't have a specific memory of seeing it, though.
Exactly. After seeing this, you were the one who supplied Jessica drinks throughout the night, right?
Yes, I was the server that night, so Frank, the bartender downstairs, would mix the drinks, and I would take them up.
Now, I'd like to talk a little bit about your interactions with Jessica Marks that night. You talked to her about 8 to 10 times that night, right?
To my best recollection, I believe so, but never for more than a minute at a time.
Exactly. And every time you went to the table, you would talk to Jessica and Morgan Levin, right?
I mean, yes, that is the polite thing to do as a server.
And all the times that you were up on your rooftop that night, Jessica and Morgan were there as well, right?
I can't really say. I was bouncing around the tables. I don't know if they stayed up there the entire night, moved down to the bar. I was pretty busy, but I did see them on the roof.
Now, I want to show you a video that was previously shown on Mr. Levin's direct. Your Honor, my second chair is now pulling up what it was previously marked as Exhibit 10, and we'll play it for the jury one more time.
Yes.
Although the audio seems to not be functioning.
Okay, your second chair can take a moment to see if they can correct the issue.
Yes, Your Honor.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy, Mom and Dad. You've inspired me. Okay, well, go big or go home.
Now, I want to put that video on a timeline. Now, you saw this timeline on Mr. Levin's direct, right?
I did. I do remember seeing it.
Now, I want to talk about whether you saw Jessica acting the same way she was in this video. You can see the 2 timestamps of the pictures Miss Levin took that night of the food at their table, right?
Yes, 10:57 and 11:32.
Exactly. The photo on the left was taken at 10:57, right?
That's what it seems to be.
That was 14 minutes before the video of Jessica was taken, right?
If I'm doing my math correctly, yes.
And the photo on the right was taken at 11:32 p.m.
That is also what it shows.
That's 21 minutes after the video of Jessica was taken.
Yes.
In fact, there's a difference between these 2 tables, right?
From what I can see, there does seem to be a difference in the number of drinks.
The chips and guac aren't on the table anymore, right?
Yes, they've been removed.
The wine is gone,
That's true.
and there is 1 less seltzer can.
Yes, I believe so.
And like you said on direct, you were the only one clearing tables that night, right?
Yes, we were a bit short-staffed, so I had to do everything.
So that means at some point between those 2 times, you went to Jessica's table.
Well, yes, someone must have cleared those drinks off.
In fact, because you went to that table, you must have interacted with Jessica around the same time that video was taken.
I'm not sure if it was around the same time, maybe within, like you said, 21 minutes, but I never saw her acting like that.
In fact, you served Jessica a green tea shot even after that video was taken right before they left your bar, right?
Yes, I believe that was the last thing the 2 ordered.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Briefly, Your Honor, may I proceed?
Yes, please.
Now, Ms. Mehta, did you serve Jessica Marks because you saw her ID?
I'm sorry, could you clarify your question?
Did you serve Jessica Marks on March 24th because you saw her fake ID?
No, it wasn't because I saw her ID and I thought it was fake. It was because she was a customer, so I served her.
And do you even remember seeing that fake ID on the day of the incident?
Well, I must have carded her because that's just my policy. It's any bar's policy, but I don't have a specific memory of seeing that ID.
Now, Ms. Davoudpour just said that you served Miss Marks green tea shots after seeing her act the way she did in that video. But I just want to remind the court really quickly, did you ever see the way she was acting in that video on that night?
Objection, Your Honor, leading, this question results in a yes or no answer from the witness. And this is direct, we'll redirect.
Right. Well, the question was, did you ever see her acting the way she was acting in the video?
And I
That's the
believe,
question.
yes, Your Honor.
Okay, so how does the plaintiff contend that that's leading?
Your Honor, we believe that the witness will either be able to reply a yes or a no to the question, and that's not the type of questions that are allowed on direct examination.
I'm going to overrule the question. I don't believe the question is leading. It's asking her yes or no. Did she see what we've seen in the video? And I don't believe that the question suggests what the answer should be, which is the definition of a leading question. So the objection to overrule, the witness may answer the question.
Yes, Your Honor.
Now, Ms. Mehta, I'm just going to repeat the question again. Ms. Davoudpour just came before you and said that you served Jessica Marks a green tea shot after you saw her act the way she did in that video. But did you, throughout any point that night, see Jessica Marks act the way she did in that video?
No, never. She'd never acted that way around me.
So when you did serve Jessica Marks those green tea shots, how was she acting?
Completely sober, like she was the entire night.
No further questions, Your Honor. We just ask that Ms. Mehta step down from the stand.
In a moment, any further any recross?
No, Your Honor, no recross.
With no recross, the witness is excused and witness may step down. Any further witnesses or evidence on behalf of the defense?
No, Your Honor, at this time, the defense rests its case in chief.
All right, thank you. One moment. All right, we will now hear closing arguments from each party. Everyone should please switch back to speaker view. Also, since both witnesses have completed their testimony, you can complete the witness portion of your ballot. That's instruction to the scoring attorneys. Just give the attorneys just the scoring judges just a moment to do that.
Your Honor, also, may we have a quick 5-minute recess just so that I could quickly use the restroom before closing arguments begin?
Yes, okay, it is 10:11 on my clock. We'll take a 5-minute recess.
Yes, Your Honor.
right, do we have both counsel back?
Your Honor, the defense counsel is here.
Thank you.
Your Honor, the plaintiff counsel is also here and ready to proceed.
Thank you very much. All right, we will proceed then with closing argument, starting with the plaintiff, please.
Yes, Your Honor. And may it please the court, opposing counsel, members of the jury, it's just common sense. Members of the jury, Jessica Marks was just a teenage girl. She and her friend decided to go out to a rooftop bar and have a good time. And instead of the owner of the bar, Sunny Mehta, doing his job that night and cutting off a girl who was obviously intoxicated, he decided to look the other way and supply her with alcoholic beverages. And Miss Yousuf has come up here and said that it was Jessica Marks's choice to do that. Yet it was Sunny Mehta's responsibility to not let her. And that's why we've sued Sunny's Rooftop Bar. As the plaintiff in today's case, we've come to court today with the burden of proof. We had to prove that the defendant should have known Jessica Marks was obviously intoxicated and that her intoxication is what led to her death. We had to prove these claims by a preponderance of the evidence. But all this means is that we had to prove to you that our case is what happened, more likely than not. And today in court, we met this burden by showing you that it's just common sense. Now, something we can all agree on is that Sunny Mehta was around Jessica Marks all night. She served her drinks, she cleared all the tables, she took all the orders. How could Mr. Mehta not have known Jessica was drunk when they were interacting all night? He was the only person there to serve her drinks and take her orders. But the defense has come here asking you to solely trust Ms. Mehta's word. However, we as the plaintiff have brought you tangible proof. Tangible proof that Morgan Levin showed us. Today in court, you saw the video of how Jessica was acting at Sunny's Rooftop Bar, right upstairs, just a couple of feet away from Ms. Mehta all night. In fact, today we showed you a timeline of when the video was filmed. You saw two pictures of Jessica's table that night. One picture was taken at 10:57 p.m. and the video was then filmed at 11:11 p.m. and the last picture was taken at 11:32 p.m. And the pictures, you can clearly see the difference in the tables. There's no chips and guac, the wine was gone, there's one less seltzer can. And even Miss Mehta came up here today and admitted to you that she saw those differences. She told you she must have gone through and cleared the tables because they were short-staffed that night. And she was the only one clearing the tables. Therefore, members of the jury, ask yourselves, because it's just common sense. Ms. Mehta had to have seen Jessica acting the way she had in those videos because Jessica was so obviously intoxicated from the drinks that she provided her that she can't completely change the way the alcohol was affecting her as soon as Ms. Mehta walked right up. It's simply unreasonable to believe that Ms. Mehta didn't see her acting that way. Yet, even though Jessica was acting like this, Ms. Mehta still served Jessica a green tea shot. She still allowed Jessica to have more alcohol, even though it is her duty as a bar owner in the state of California to not overserve. It's just common sense. Today in court, you heard from Morgan Levin. She told you that Jessica Marks was acting obviously intoxicated all night. She explained how she was slurring her words, her eyes were bloodshot, but she also told you that she saw Jessica stumble and fall onto the bartender. But instead of never giving them drinks, instead of never cutting them off, instead of making sure that she was okay, Mr. Mehta just made a joke about it. He said, someone should cut her off. He said, I hope this one's not driving. He still continued to serve her drinks. It's just common sense. Your Honor, I'd like to reserve the rest of my time for rebuttal.
Thank you. Defense, you may give your closing argument.
Yes, Your Honor. The life of Jessica Marks was in her own hands. It's difficult to acknowledge this. We can't deny the truth. The circumstances as to why we're here today are tragic. The pain Jessica Marks and her family have had to endure with this loss is terrible. But when the plaintiff walked into this courtroom here today and pointed the finger to my client, Sunny Mehta, and her family, that's something we took lightly. And the law clearly states that with an accusation like that, the plaintiff has a burden of proof. And the law clearly states this burden must be met with evidence. Many times as Ms. Davoudpour came before you and said, common sense, common sense, common sense, it's not up with evidence. And saying the word common sense does not make it true. Let's clear up some things regarding their burden and the elements of today's case that the plaintiff actually got wrong. Members of the jury, this is not a negligent case. Ms. Davoudpour just came up here and said that the bar had a duty to stop serving drinks to Jessica Marks, but that is not the case. We're here for a wrongful death case using the Dram Shop Act. But those two that the plaintiff needed to prove, and those elements were that Sunny Mehta knew Jessica was obviously intoxicated when they served her, and two, Sunny Mehta caused Jessica Marks' death. So let's talk through these elements and the evidence that they brought to you to prove their claims. First of all, they said in their closing argument, they said about the person serving Jessica Marks drinks that night, but you heard from their own witness, Morgan London, that Jessica told her she didn't drink from other people. She told Morgan London that Jessica Marks got drinks from Frankfurt, another bartender. Yeah, that's what the plaintiff just said in their closing argument. And I want to talk about these elements specifically. First, nowhere in court today did the defendant, Sunny Mehta, actually admit to knowing Jessica was obviously intoxicated. Simply saying it's common sense does not make it so. Forth between tables, she said conversations didn't take more than a minute between them. She first saw the way Jessica was acting, and no evidence today showed that. The only witness that came before you that the defendant knew that was Morgan Levin. So let's talk about Morgan Levin. The witness that she repeatedly before this trial took place and even during it. If she had fireball that night, she said she couldn't remember. She was having drinks with other people she never mentioned in her testimony, her deposition, or even on the stand. We showed you that other patrons were having drinks with them. On the receipt, the bar had no idea. And Jessica was the one that took these shots. Jessica was the one that took the rum and coke that wasn't on the receipt either. Didn't know about either. Now, members of the jury, if Sunny Mehta didn't overserve Jessica, then they couldn't have been the cause of her death. If you do feel that the plaintiff has met their burden, even with a witness who doesn't know the testimony that they're giving, we'll bring forth an affirmative defense. And with that, we had the burden to prove by a preponderance of the evidence, more likely than not, that it was Jessica's actions that led to her death instead of Sunny's rooftop bar. So it does make common sense because we have evidence to back it up. You say that it was Jessica who had the fake ID to get to Sunny's bar. You today, it was Jessica who took the drink and the shots and the beers and the wine. Even before entering Sunny's bar, she had a glass of wine. These drinks were in her hand. The keys were in her hand. It was Jessica. The keys were the ignition and started it, even after Morgan Levin told her repeatedly not to drive. People were telling her not to drive, and she still did it anyway. Now, remember, Sunny Meta didn't know how Jessica Marks was acting that night. She was jumping between tables. But these are the choices that Jessica Marks did in her hand. The fake ID. She had the drink. She had the car keys, and she had the steering wheel in her hand. She drove to Sunny's bar with the intention to drink. She didn't go in an Uber. She wasn't the intention to drive in it. As difficult as it is to think about this, what caused the death of Jessica Marks wasn't Sunny Meta. It was Jessica Marks's choices. Her ID, her drinks, her car keys, her steering wheel, her life, her choice to be or not to be a reasonable driver on the road. These were all her choices. One thing leads to another. It's not common sense that one person who doesn't even remember what happened that night, that Sunny saw something that Sunny never did. These are common sense members of the jury. Jessica's choices, Jessica's life in her own hands. When you go into that jury deliberation room, we are confident that you will find Sunny's Rooftop Bar not liable. Thank you.
Thank you, counsel. Rebuttal by the plaintiff, please.
Yes, Your Honor. May I proceed?
Yes, please.
Your Honor, the defense brought forth an affirmative defense, meaning that they had to prove that Jessica Marks's death was caused by her own negligence. The defendant must have come here today and proved that Ms. Marks's own negligence was a substantial factor in causing her death, yet they didn't do that. In fact, what we had to prove was that the defendant should have known Jessica Marks was obviously intoxicated, and that her intoxication is in fact what led to her death. If you're even 51% convinced, if the scale tips even a little bit more in our favor, you have to rule in favor for the plaintiff. Ms. Yousuf's entire case is based on Sunny Meta's words and her choices. Now, I want to talk about some of those words and some of Ms. Meta's choices. In fact, I want to go back to Ms. Meta's testimony on stand today, because I actually wrote down a few things that she said today just to make sure I got them right. She said that she never saw her acting the way she did in that video, even though she was around the bars all night, she was up at the rooftop, and like she said, it was a Sunday evening. It wasn't that busy. There was only 2 of them. Then she also said when she served her a green tea shot at the very end of the night, Miss Marks was completely sober. Although Miss Meta had served her many drinks throughout the whole night. She chose to serve her all those drinks. How could she be completely sober? Now, does that really make sense? Does it make sense that a 5-foot, 19-year-old girl would drink almost a whole bottle of wine, 3 hard seltzers, a beer, a round of shots, and a mixed drink, and still be okay? And still seem completely sober? No. Members of the jury, it's just common sense. Instead of just trusting Sunny Meta's words, which is all the defense was actually able to bring you today, Trust actual tangible evidence that we've brought. It's just common sense. Hold the defendant liable. Thank you.
Thank you to both counsel and all witnesses. At this time, scoring judges, you should complete your ballots at this time and click submit. I'm going to ask the bailiff to please confirm